Finally, after we first brought in the application for the judicial review on the fatwa against us, I think the proper hearing, we feel, has finally begun today after 2 postponements. So it's been many years. It's already been 5 years, and we're happy that the hearing is going on, and we have faith and confidence in the judiciary. We hope that all matters will be looked at, and the issue is that this particular fatwa doesn't just apply to sisters in Islam. It actually applies publicly to everyone, because it says there, any persons, SIS Forum Malaysia, organizations and individuals that profess or subscribe to liberalism and legal pluralism would be regarded as deviants. So this is a public interest matter, and I think the decision that the court takes has to bear in mind that all Malaysians or Muslims in Malaysia are affected by the decision of this fatwa.
Yeah, so I think the matter has a long-standing litigation history. It was filed in 2014. Leave was in fact previously given despite there being objections. I mean, in short, the matter went up to the federal court, and the federal court then directed it go back by consent to the High Court to be decided both on jurisdiction and on the merits as well. So what happened today essentially was a hearing of the proper judicial review application, both on the issue of jurisdiction and regardless on how that is determined on the merits of the case as well. And I think we had a good chance to be heard earlier. It was a full hearing. We have submitted on all issues. Just to summarize it, our position is that the civil courts have jurisdiction because the issue is one that goes to the Constitution and interpretation of federal and state laws. And as Rosanna has said, it affects the fundamental rights of not just SIS Forum, but all persons professing the religion of Islam. And that's something only the civil courts can determine. And on the merits, well, we've argued what we have argued. So at the end of it, I think the court question of Section 66A in the state enactment was raised. That section confers the Sharia court powers of judicial review. Now what happened was previously it was raised as well. That section only came into force in 2015 after the application was filed, and parties at that point generally agreed it wouldn't apply to this case. Now it was raised again, and I think the High Court has asked us to put in further submissions on 66A on whether it applies, if it does, whether it's valid. So that has to be done in 2 weeks from today, and the decision has been fixed on the 20th of August. So we will get a decision in full by then, on that date. Sharia court, then you might say that you go to the Sharia court and then we sort it out there. In the ones that we filed so far, we have not because of the agreement we had, but now that we're going to do it in a separate submission.
I mean, one is the retrospective,
and in any event, it is unconstitutional. It was just a 3-month timeline, because it just says how to do it. It doesn't have a procedure for anything of that sort. They don't know. You don't know how to do it, when to do it, all that.
Before the respondents.
Yeah, that's because the rules of court imposes a 3-month deadline. Well, 66A